My name is Justin Myers and I am a Utah bankruptcy attorney. Today we are going to be discussing pre-bankruptcy property transfers, otherwise known as fraudulent transfers. This and other topics can be read about in my book entitled Filing Bankruptcy in Utah. You can order a free copy of this book on the website utahbankruptcybook.com. You can also call my office at 801-308-8200 and set up a free initial consultation to meet with me. Debtors often wonder if they can transfer property, such as homes or vehicles, out of their names and into the names of family members or friends in order to avoid losing the property in bankruptcy. This is called a fraudulent transfer and is not allowed for obvious reasons. In the context of a bankruptcy, a fraudulent transfer is any transfer of property or transfer of an interest in any property made within 2 years of filing the bankruptcy that was made either with the intent to defraud or delay collection efforts of the debtor's creditors. An example of this would be the debtor transfers all of the debtor's property out of his or her name personally and into the name of a newly formed shell corporation in order to thwart the collection efforts of creditors. Or if the transfer was made for value that was less than reasonably equivalent to the value of the property that was transferred. An example of this would be a debtor that sells a $10,000 car to his mother for $500. The trustee has the right to undo these types of transfers. For instance, with the car example, the trustee could go after the mother and legally obtain possession of the car. Generally, if this was done, the trustee would pay $500 to the mother. If the mother had sold the car, the trustee could sue the mother for the value of the car that was given or for $10,000. Under the bankruptcy code, trustees can go back 2 years for any of these types of transfers. However, most states have separate state laws that allow the trustee to go back further in time to deal with this type of transfer. In Utah, trustees can go back 4 years. A debtor is required to list all of these types of transfers on the bankruptcy schedules that are filed with the court. If the debtor fails to list these types of transfers, the debtor could have his or her bankruptcy discharge denied or revoked, or could even face bankruptcy fraud criminal charges.